long-shot bid to backtrack on his plea deal.
Are you pleading guilty because you are guilty?
Yes.
Court records now showing a new public defender assigned to Kohberger's case, more than a year after he agreed to a plea deal, admitting in open court to killing 4 University of Idaho students, Kaylee Gonsalves, Madison Mogen, Ethan Chapin, and Xana Kernodle, in their off-campus home. In handwritten documents filed last week, Kohberger now saying he was convinced to falsely confess by coercion, disinformation, false promises, and the withholding of exculpatory evidence. Also accusing his former public defender of ineffective assistance of counsel and suggesting without evidence that his plea deal was not voluntarily entered because of threats asserted by petitioner's legal counsel. Despite the new attorney, legal experts in Idaho say his new efforts are almost certain to fail.
The murder of Madison Mogen, how do you plead guilty or not guilty?
Guilty.
For the murder of Kaylee Gonsalves, how do you plead guilty or not guilty?
Guilty.
The murder of Xana Kernodle, a human being, how do you plead guilty or not guilty?
Guilty.
The murder of Ethan Chapin, a human being, how do you plead guilty or not guilty?
Guilty.
He spent years learning how killers think, how they choose their victims, how they move through a crime scene, how they avoid leaving evidence behind. He studied the psychology of violence, interviewed convicted felons about their crimes, and wrote papers analyzing the minds of murderers. His entire academic career was built around one question: what separates someone who kills from someone who doesn't? On November 13th, 2022, police say Brian Kohberger stopped asking that question and became the answer. 4 college students were found dead in an off-campus house in Moscow, Idaho. For 47 days, investigators had no suspect, no weapon, no clear motive, just a single microscopic piece of evidence that would eventually lead them to a doctoral student in criminology living less than 10 miles away. Someone who had been watching. Someone who had been returning to the area again and again. Someone whose phone records would reveal a pattern that started months before anyone died. This is the case that paralyzed a small university town, confused a nation trying to understand how something like this could happen, and ultimately raised a question that still hasn't been answered. Did studying killers teach him how to become one? This case is still moving through the courts, and there are developments happening that most coverage isn't explaining clearly. If you want true crime cases broken down the way investigators actually see them, without speculation or sensationalism, subscribe to Crime Dive Network right now. I'm covering every legal step of this case as it unfolds, and you don't want to miss what's coming next. Moscow, Idaho was never built for headlines. 25,000 people. A college town tucked into the northern panhandle where the rhythm of life follows football Saturdays and final exams. The kind of place where doors stay unlocked and nights feel safe. In November 2022, 4 students living just blocks from campus were building lives that had barely started. Kaylee Gonsalves was 21, a senior, a member of the Alpha Phi sorority. She grew up in Rathdrum alongside her best friend Madison Mogen. They were raised like sisters. Graduation was weeks away, and Kaylee had plans. A backpacking trip through Europe. A job waiting in Austin, Texas. The day before she died, she and Madison spent an afternoon taking photos together on the porch of the house they shared. The kind of ordinary moment that only becomes unbearably significant later. Madison Mogen was 21 as well. From Coeur d'Alene, a member of Pi Beta Phi. People who knew her said she was the sister everyone wished they had. Patient, warm, the one who always gave the best advice. One of her surviving roommates would later describe losing Madison as losing a second mother. Xana Kernodle was 20, a junior studying marketing, also Pi Beta Phi, originally from Post Falls. At her high school graduation, she decorated her cap with hand-cut flowers and butterflies. Across the top, a single handwritten line, "For the lives that I will change." Her older sister Jasmine would later say Xana was one of the best people she had ever known. Someone with so much life left to live. Ethan Chapin was 20, one of a set of triplets who had enrolled at the University of Idaho together the year before, alongside his siblings Maisie and Hunter. He was studying sports management. He was a member of the Sigma Chi fraternity. He was Zana's boyfriend, staying at the house that night, the way he often did. His mother, Stacy, would describe him as someone who lit up every room he walked into, the kind of presence a family builds itself around. These four were not strangers to each other. They were roommates and partners, best friends, and the people each other called first. In the early hours of November 13th, 2022, all four of their lives ended inside that house on King Road. Two other roommates were home that night. They survived. What followed in Moscow was not simply grief. It was collective disorientation. There had not been a homicide in the community in years. Suddenly, there was no name, no motive, no weapon, and no answers. Only 4 young people gone, and a population left wondering who among them might be capable of something like this, or whether the person responsible had already left town entirely. Locks went up on doors that had never needed them. Parents drove through the night to bring their children home early, unwilling to wait out the semester with no suspect in custody. The University of Idaho, an institution built around routine and small-town familiarity, was left trying to hold itself together while the entire nation began watching. At a memorial service held in the days after, one of the surviving roommates stood and read a statement through a pastor. She said her friends lit up every room, and that she wished every day she could give them one more hug and tell them how much she loved them. Investigators, meanwhile, had almost nothing solid to work from. No confirmed motive, no recovered weapon, no named suspect. What they did have was a single imprecise detail, a partial description of a car, a light-coloured sedan seen in the area around the time of the killings. On December 7th, Moscow police made a public appeal asking anyone who recognized a white Hyundai Elantra, model years 2011 through 2013, to come forward with information. That single detail became the thread investigators pulled on for weeks. A task force made up of local police, state investigators, and the FBI began reviewing thousands of hours of surveillance footage pulled from businesses and traffic cameras across the region, trying to trace that one car through a sea of ordinary daily life. Eventually, the trail led to a registration, a white 2015 Hyundai Elantra, owned by a 28-year-old man living less than 10 miles from the crime scene, just across the state line in Pullman, Washington. His name was Brian Kohberger. At the time, he was a doctoral student in the Department of Criminal Justice and Criminology at Washington State University. Someone who had spent years studying the psychology and behavior of people who commit violent crimes. Now, without warning, at the center of an active homicide investigation into 4 murders. But the car alone wasn't enough. At the scene, investigators had recovered a knife sheath carrying a single source of male DNA. Using forensic genetic genealogy, a technique that compares crime scene DNA against public genealogy databases to identify potential relatives of an unknown suspect, investigators traced a distant family connection back to the Kohberger family in Pennsylvania. To confirm the link with certainty, they collected a discarded sample from trash outside the family's home and compared it directly against the DNA from the sheath. It matched. Separately, cell phone records painted their own picture. Investigators say Kohberger's phone connected to the area near the King Road house at least a dozen times in the weeks leading up to the killings, with the pattern dating back to August. Records also showed an earlier purchase. A knife and a matching sheath, the same style recovered at the scene, bought through an online retailer months before the murders occurred. Digital forensic analysts later uncovered something else. In the days after Moscow police went public with their search for the white Hyundai Elantra, records show Kohberger had researched and downloaded lists of similarly registered vehicles near the university. Someone quietly watching from the outside, tracking exactly how close investigators were getting to him. By mid-December, they were close enough. As Kohberger drove cross-country toward his parents' home in Pennsylvania to spend the holidays, an FBI surveillance team began tracking his movements, following him for 4 days without making contact, while investigators and prosecutors worked to finalize the legal groundwork needed for an arrest warrant. In the early morning hours of December 30th, 2022, that warrant was executed. Pennsylvania State Police and the FBI arrived at the Kohberger family home in Chestnut Hill Township. There was no standoff, no chase, no resistance. His father answered the door. Brian Kohberger was taken into custody without incident. More than 6 weeks after the killings, roughly 2,500 miles from where they happened, in the quiet of a residential neighborhood far removed from the college town that had spent a month and a half in fear. He was extradited back to Idaho in the first days of January 2023. A probable cause affidavit unsealed shortly afterward laid out for the public. For the first time, the case investigators had been quietly building behind closed doors. The car, the DNA, the cell phone data, the online purchase. In May of that year, a grand jury formally indicted him on 4 counts of first-degree murder and 1 count of burglary. But what followed was not a quick resolution. More than 2 years of pre-trial motions, hearings and delays stretched out ahead of the case. Kohberger's defense team, led by Ann Taylor, a public defender with nearly 3 decades of experience, argued that after so much sustained national coverage, he could not receive a fair trial from a jury selected out of Latah County, the small community where the killings happened, and where the case had consumed daily conversation for years. A judge agreed. The trial was moved nearly 300 miles south to Ada County in Boise, and a newly assigned judge took over the case. Defense attorneys filed more than a dozen motions attempting to suppress key evidence. The cell phone records, the internet search history, the results of warrants executed on his car and his family's home. Nearly all of that evidence survived the challenges and remained admissible. Prosecutors have announced they are seeking the death penalty. Kohberger has pleaded not guilty. 13 months of silence. After Brian Kohberger was sentenced in July 2025 to 4 consecutive life terms without parole, he disappeared from headlines almost entirely. No filings, no public comment, no interviews. Just silence from inside Idaho's maximum security prison south of Boise. To most of the country, and perhaps even to the families themselves, the case read as finished. 4 life sentences. A door closed. Then, on July 27th, 2026, from inside his cell, without hiring an attorney, Kohberger wrote and filed a legal petition entirely by hand. Page after page of his own handwriting, submitted directly to the Ada County District Court, asking a judge to undo the very agreement that had spared his life just over a year earlier. The petition makes 3 specific claims. Each one accuses his own defense team of failing him. Each one asks the court to do something that should be nearly impossible. Erase a guilty plea he gave under oath, in open court, in front of the families of 4 murdered students. If a judge agrees, the case reopens. The guilty plea disappears. And the deal that removed the death penalty from the table? That disappears too. This is the story of what happens when a closed case tries to become an open one again. This case is about to move through a legal process that most people never see explained clearly. If that's the kind of breakdown you're looking for, this is exactly where to get it. Hit subscribe to Crime Dive Network right now, because what happens next in this case unfolds over the following weeks, and I'll be covering every stage of it as it happens, not after the fact. To understand what Kohberger is asking for, you first have to understand exactly what he gave up in that courtroom. When Kohberger accepted his plea deal in July 2025, he didn't just admit guilt. He formally waived his right to ever appeal the conviction, a waiver designed by its very nature to be permanent. It's the trade defendants make in exchange for certainty. No more hearings, no more uncertainty. No reopening old wounds for the families who have already lived through years of waiting. Once signed, it's supposed to be the end. But there is one narrow door that waiver cannot lock. And it exists because of a case that, on its surface, has nothing to do with Idaho. Underneath, it has everything to do with it. In 2019, the United States Supreme Court decided Gaza versus Idaho, a case asking whether a defendant who signs away his appeal rights can still challenge the performance of his own attorney. The court ruled yes. Certain constitutional protections, specifically the right to competent legal counsel guaranteed under the Sixth Amendment, cannot be signed away by a plea agreement, no matter what the paperwork says. The reasoning behind it is simple. No one should permanently lose their freedom because the person defending them failed to do the job the Constitution requires, and no signature on a plea deal can erase that safeguard. This is the exact door Kohberger is now attempting to walk through. Not an appeal. A separate, narrower legal mechanism known as post-conviction relief. An appeal asks whether a trial was conducted fairly. But there was no trial here. Post-conviction relief asks a different question entirely. Was the guilty plea itself legally valid? Was it truly voluntary? Truly informed? Entered free of coercion? Or was it built on incomplete information? Or worse, on information that simply wasn't true? There's a deadline attached to this kind of filing, and it isn't generous. Idaho law gives defendants roughly 1 year from the close of their appeal window to bring a claim like this forward. For Kohberger, that clock was set to expire in the first week of September 2026. His handwritten petition, filed in the final days of July, arrived with weeks to spare, cutting it closer than any experienced attorney would ever advise, but landing inside the window all the same. He was representing himself. No legal team monitoring that deadline on his behalf. No lawyer reviewing his arguments before they were submitted. A man with no formal legal training, working entirely alone from inside a cell, filing one of the most complex types of motions in criminal law, with only weeks left before the door closed permanently. Inside that filing, Kohberger lays out 3 specific claims, each one aimed squarely at the same target, the legal team that once fought to save his life. The first concerns physical evidence. Kohberger alleges that his attorneys failed to properly disclose or fully investigate a piece of forensic evidence connected to one of the victims. Unidentified hair recovered at the scene that, according to his filing, was never fully tested or explained to him. He argues that leaving that lead unexamined amounts to withholding something that might have worked in his favor, and that he was never given a genuine opportunity to understand what it meant before agreeing to plead guilty. The second claim turns inward, toward what he says he was promised about his own future. Kohberger alleges his legal team painted an inaccurate picture of daily life under a sentence of life without parole, describing conditions, according to his petition, that do not match what he says he has actually experienced behind bars in the months since sentencing began. The third claim looks at the other side of that same coin, what he says he was told about the alternative he was avoiding. Kohberger alleges his attorneys described conditions on Idaho's death row in exaggerated, frightening terms, intended, he claims, to push him toward the plea out of fear rather than out of genuine, informed choice. Individually, each claim is specific and narrow. Together, they form a single argument that the guilty plea he gave under oath, in open court, in front of the families of 4 victims, was not the free and voluntary decision the official record shows it to be, and that it should be erased entirely, wiped from existence, as though it never happened. There is a risk attached to that request that Kohberger cannot avoid, and his own petition does not pretend otherwise. If a judge grants it, the guilty plea disappears, and so does the deal that came with it. The death penalty, removed from consideration just over a year ago, returns fully to the table. Whether prosecutors would seek it again is unknown, but the legal possibility, once eliminated, would exist again in full. Whether any of these 3 claims can actually clear the legal bar required to undo a signed, sworn guilty plea is now a question sitting on a judge's desk in Boise. To answer it, you have to understand exactly how high that bar really is. And it's considerably higher than most people assume. To succeed, Kohberger doesn't simply need a judge to find his claims believable or even sympathetic. Idaho law requires proof of what's legally defined as a manifest injustice, a standard reserved for the rarest of cases. Ones where the record itself reveals that something went fundamentally wrong at the exact moment the plea was entered. It is not a standard built for second thoughts. It is not built for regret, or for a changed mind after 13 months of isolation. It exists specifically to prevent finished, resolved cases from being reopened simply because a defendant, months or years later, wishes he had chosen differently. And the record Kohberger is fighting against is not vague, not a matter of fading memory or shifting interpretation. It is a transcript. During his change of plea hearing in July of 2025, Judge Stephen Hippler did not ask a single question and move on. He conducted what's known as a plea colloquy, a detailed methodical sequence of questions specifically designed to withstand exactly this kind of future challenge. He asked whether Kohberger understood each right he was giving up. He asked whether anyone had threatened, pressured, or coerced him into the decision. He asked whether Kohberger was satisfied with the attorneys standing beside him. And for each of the 4 murder charges individually, he asked whether Kohberger had committed that specific killing.
The murder of Madison Mogan, how do you plead guilty or not guilty?
Guilty.
For the murder of Kaylee Gonzalez, how do you plead guilty or not guilty?
Guilty.
The murder of Xana Kernodle, a human being, how do you plead guilty or not guilty?
Guilty.
The murder of Ethan Chapin, a human being, how do you plead guilty or not guilty?
Guilty.
Every answer is preserved, word for word, on the official court record. Every answer at the time was yes to guilt, and no to any pressure or coercion. That transcript doesn't disappear, because Kohberger now says something different from inside a cell more than a year later. If anything, it becomes the central piece of evidence prosecutors will use directly against his own petition. A document, in his own recorded words, contradicting the very claims he's making now. Then there's the matter of who exactly he's accusing. The attorney at the center of his allegations is Ann Taylor, lead counsel throughout his defense. Taylor is not a novice public defender assigned at random to a case beyond her experience. She has spent close to 3 decades practicing criminal defense, more than half of that specifically as a death penalty qualified defender. A specialized certification requiring extensive additional training, precisely because the stakes in capital cases are so severe and so final. Throughout the pre-trial years, her team filed motion after motion, challenging nearly every piece of evidence prosecutors brought forward. And by outside legal assessment, they mounted one of the most aggressive, thorough defenses the state had seen in a capital case in years, convincing a judge that an attorney with that record failed to meet even the constitutional minimum required for a Sixth Amendment violation is not a small legal hurdle. It may, in fact, be the hardest single part of everything Kohberger is now asking the court to accept. Behind every legal standard in this case, behind every procedural deadline and evidentiary threshold, are 4 families who were told just over a year ago that this chapter of their lives was finally, mercifully, closing. Kaylee Goncalves' family responded to the news publicly within hours of it breaking. Their statement doesn't dwell on legal terminology or procedure. It goes straight to the choice Kohberger made in that courtroom, noting plainly that he chose not to leave his fate, or the facts of the case, to a jury. They add that they too had wanted this case decided at trial, with the death penalty argued in full and openly, rather than resolved quietly through a plea agreement behind closed doors. Their statement closes with a single sentence that carries more weight than any court filing ever could. He wants another chance to roll the dice. That sentence appears nowhere in Kohberger's petition. It factors into no legal test any judge will apply, but it captures something the legal process was never designed to measure in the first place. What it actually means for a family to be told once that a case is over, and then be told again, 13 months later, that it might not be after all. What it means to have built a foundation in your daughter's memory. To have started turning grief into something that might help other families find their own answers. Only to be pulled back, without warning, into the very case you were trying to move forward from. So what actually happens from here, in practical, procedural terms? The process ahead is neither immediate nor simple, and it unfolds in distinct stages, each one capable of ending this entirely, or pushing it forward into the next. First, a judge in Ada County reviews the petition to determine whether it even meets the minimum legal threshold required to proceed at all, a preliminary filter, deciding only whether the claims, if ultimately proven true, could theoretically amount to a manifest injustice. This stage is not a ruling on whether Kohberger is telling the truth. It's simply a gate, deciding whether the case is allowed to continue past the first step. If the petition clears that stage, prosecutors are given the opportunity to file a formal response, almost certainly disputing each of the three claims individually and in detail, very likely pointing directly back to the plea colloquy transcript as their central piece of evidence. Only after that exchange does the court decide whether the case has earned what's known as an evidentiary hearing, a proceeding where, for the first time since the original plea, witnesses could actually be called to testify under oath. That witness list could include members of Kohberger's own family, present, according to his petition, during the very conversations where these promises and warnings were allegedly made. None of this moves quickly, and none of it is guaranteed to move forward at all. Realistically, this entire process unfolds over months, filing by filing, hearing by hearing, with no certainty at any stage that it advances to the next. Strip away the legal terminology, and what remains is this: a set of claims that must clear one of the highest bars in criminal law, working directly against a sworn transcript that contradicts them point by point, aimed at one of the most experienced capital defenders in the state. Filed without legal counsel, arriving just weeks before the only opportunity to file at all would have expired permanently and forever. None of that guarantees failure, but it explains, in specific and concrete terms, why legal experts following this case describe Kohberger's odds as narrow. Not because of speculation or gut instinct, but because of precisely what stands between his petition and a courtroom. The question now is whether a judge will see manifest injustice in a plea that, at the time, appeared to follow every procedural safeguard the law requires, and whether four families who were told this case was over would be forced to relive it all over again. This channel is tracking every one of those filings the moment they happen, not days later, not after every other outlet has already moved on to something else. If you want to be here for that, subscribe to Crime Dive Network now, and I want to hear from you directly. Given everything laid out here, the transcript that contradicts him, the timeline he barely met, and the standard he now has to clear, do you think a manifest injustice claim like this one ever actually succeeds? Leave your answer below, and I'll see you in the next update.